Could be 300 days, it could be 3 years. HR exists at the pleasure of the employer. You feel that you're being discriminated against.
So, what role does timing play in legal action, and what are common mistakes people make because they don't know their rights?
Timing's huge. If you don't file within the allotted time for your particular claim, you could be foreclosed and you can't have a case ever. Like, you just lost the ability to do something about it. So for example, for federal claims under Title VII that I mentioned before, you generally have 300 days to file with the EEOC if you want to pursue that particular statute. In some states, it's shortened to 180 days. If you're just suing under the state law, it could be 300 days, it could be 3 years. It all depends. I mentioned before the Trafficking Victims Protection Act, the sexual assault victims at work. That actually has a very long statute of limitations, and that is 10 years. So it could have happened 10 years ago and you could still do something about it. The other is that race statute I mentioned before, 1981, federal, all over the United States. That gives you 4 years to do something about it. So it's very important to remember that you do have deadlines. It depends what your lawyer is going to want to bring, but the shortest of them could be as short as 180 days. So call a lawyer fast, do something about it, and don't just assume that you have all the time in the world.
Thank you so much. Just like you said, there are limitation periods. So listeners, I hope you're taking note of this. And if someone is currently experiencing harassment or discrimination, what are the first 3 practical steps you usually recommend?
First things first. Like I mentioned, documentation is good if done properly. Document everything. 2, just pick up the phone, email, fill out the little contact form on the lawyer's website, whatever it is. Consult with an employment attorney immediately. And by the way, just because you may reach out to an employment attorney and are too busy to take your case, or they don't particularly want your case, don't give up. Try other lawyers out there. There's an organization that specializes in plaintiffs' employment law cases that's representing employees only, and that's called NELA, National Employment Lawyers Association. Go on their website, take a look and see who they have in their directory, and reach out to those lawyers who you know are specialists in representing employees. Also, this is crucial. Very often your boss is going to be looking for ways to fire you. They do. It's just retaliation. It happens. If you feel you've been discriminated against, you're making a complaint, they're going to look for ways to limit their exposure and say, oh, they're not doing their job correctly, or they just don't want you there. They're going to fabricate. Don't give them a reason to fire you. It is very important to follow your job to a T. So that means be on time. That means get your work done on time. Do it as carefully as possible. Don't give them ammunition that they will be able to use against you.
Thank you. So, how should survivors assess whether HR is a safe or unsafe space for disclosure?
People who's listening understand HR is not your friend. Okay? HR exists at the pleasure of the employer. HR wants nothing more than to protect the company and make sure your complaint goes away, and maybe even you go away. So therefore, you have a duty sometimes under the employee handbook to notify them, and you have to deal with them, but just understand they are not your advocate. We, employment lawyers, we are your advocate, and that's why it's important that you should deal with an employment lawyer rather than going to HR and expecting them to have your back, because quite likely they won't. It also is important to know that if the HR is being made aware by you that, let's say, a coworker is harassing you, they want to know that, and they do want to fire that coworker who's engaging in unlawful harassment. And in that respect, you're on the same team. Thank you for advising me of this coworker. We want to get rid of them. We fire them, and you all work together in one big happy family. On the other hand, if the harasser is a rainmaker, a senior executive, a CEO even, their boss, the last thing they're going to want to do is fire that person, and they're going to protect that person at all costs. And that's when it becomes very dangerous.
Thank you. I think you've actually answered the question, because I was going to ask what warning signs suggest the workplace may retaliate, and how can someone prepare for the risk?
signs exist that they're going to retaliate?
Yes.
The warning sign that an employer is going to retaliate is your complaint itself. The number one charge filed with the EEOC all across the country is retaliation. So just know that if you do complain, there is a huge risk of retaliation. And by the way, that could be the best part of your case, because even if you don't have such a strong discrimination or sexual harassment case, if you're retaliated against and they fire you or take an adverse employment action against you, that could be an amazing part of your case, and that could be the reason why you win in the end.
Thank you. So what advice would you give to people who feel financially trapped in abusive workplaces?
So if you feel financially trapped, so like I said, you're financially trapped and at the same time you feel that you're being discriminated against, retaliated against, call a lawyer and get advice on how do you get out there. There is a concept in law called constructive discharge, which says that where your conditions at work are so bad that no reasonable person under those conditions should expect to be working at those anymore, you have the right to quit. And if you quit under those circumstances, you could even get unemployment insurance benefits. So you can get unemployment insurance benefits. You could sue for the wrongful termination, even though you technically quit. It's that they forced you to quit. So you have a case of wrongful discharge. And so by all means, if you feel financially trapped, you don't have to take it. There are benefits that you can get. A good lawyer could help you get a lawsuit so that you can get your lost wages back. And also, very often, settlements can happen quickly, and you can get that as quick as possible. But lastly, look for another job. If you're in an abusive workplace, we live in an employment at will situation. That means, in general, aside from the protections that I mentioned before, an employer can fire you for any reason, good reason, bad reason, no reason. At the same time, you can quit for any reason, good reason, no reason, bad reason. Job, you don't like your position, pound the pavement. Go on LinkedIn, ZipRecruiter, and go ahead and find a job somewhere else. Apply all over the place, and hopefully you'll get that job and you can get out of that horrible situation.
Thank you. Listeners, I hope you're taking note of that. I do agree with you that, people can have what we call constructive dismissal. That's what it's called in the UK, constructive dismissal, due to the working environment, which might not be favorable to the employee. They will be compensated, just like you said, there are remunerations for that. But the employment lawyer will have to do something in relations to that, depending on the environment where the employee was working, bringing out some of the things that they felt was not favorable in carrying out their duties. Be safe and be positive. And don't forget to check out our social media handles. Thank you. Bye for now.